You can listen to The Front on your smart speaker every morning. To hear the latest episode, just say, play the news from The Australian.
From The Australian, here's what's on the front. I'm Claire Harvey. It's Friday, June 14. Green activists delayed more than a dozen coal and gas projects by taking court action, even though their legal cases have been unsuccessful. That's prompted the resources sector to demand the federal government speed up approvals and stop giving taxpayers money to the Environmental Defenders Office. That story's live now at theaustralian.com.au. Christopher Michael Dawson will stay in jail. He has lost an appeal against his conviction for the murder of his wife, Lynette. That case was made famous by our podcast, The Teacher's Pet, and has ended in another humiliation for Dawson. Today, the moment Lynn's family found out Dawson would stay in jail and what his next move might be.
Hello.
Oh, hi Marilyn, it's Claire.
Hi, Claire.
How are you?
That is the longest minute in my entire 71 years of living.
Just moments after a momentous decision, the latest twist in the story of Christopher Michael Dawson, I rang Greg and Marilyn Sims, the brother and sister-in-law of the wife Chris murdered in 1982, Lynette.
Well, waiting for the judges to come out, their verdict, if you want to call it that, very tense. And it's the longest minute I've had in my life. Waiting and listening.
To call Greg and Marilyn relieved would be an understatement. Greg and Marilyn are the guardians of Lynn's memory, along with the rest of her family. They're the ones who have kept the flame alive for 42 years, as their suspicions grew that their bright, warm, devoted Lynn did not voluntarily leave her family, as her husband claimed, but had been murdered in cold blood. Greg and Marilyn had liked and trusted Chris, Lynn's handsome, football-playing teacher husband. They were deeply confused and upset when he told Lynn's family in 1982 that Lynn had gone away for a break and that Lynn had told him not to worry about her. By the time the Australian's investigative podcast The Teacher's Pet, created by our colleague Hedley Thomas, was released in 2018, Greg and Marilyn were convinced Chris was a murderer. They'd seen an inept initial police investigation, then a competent investigation led by Detective Damien Loon. Then 2 coroners recommend charges against Chris, and then the heartbreak of prosecutors steadfastly declining to charge him. In August 2022, the family finally got the conviction they believed was right.
Christopher Michael Dawson on the charge that on or about 8 January 1982 at Bayview, or elsewhere in the state of New South Wales, you did murder Lynette Dawson. I find you guilty.
And then the sense of dread returned as Dawson launched an appeal against that murder conviction.
Teacher's pet killer Chris Dawson has begun an appeal against his conviction for murdering wife Lynette more than 4 decades ago.
The 75-year-old former rugby league star wants a court to overturn his conviction for killing his wife Lynette in 1982.
His legal team claims he's the victim of a miscarriage of justice and that it was unreasonable for the trial judge to find him guilty.
I spoke to Greg and Marilyn in the early afternoon on Thursday, shortly before the New South Wales Court of Criminal Appeal handed down its decision. They were nervous then, and by the time the 2 p.m. hearing clicked around, they told me they had knots in their stomachs. The judges swept into the room and took their seats for what turned out to be a lightning-quick sitting of the Court of Criminal Appeal, New South Wales's highest court. The judges' words are being read by voice actors.
I propose the following orders. 1. Grant leave to appeal. 2. Dismiss the appeal. I publish my reasons.
Justice Payne?
I agree with the orders proposed by Justice Adamson, and I publish a note of my reasons.
I agree with Justice Adamson and with the supplementary observations of Justice Payne, and I publish my concurring judgment. The orders of the court will therefore be: 1. Grant leave to appeal. 2. Dismiss the appeal. Court is now adjourned. In other words, the judges accepted Chris Dawson could appeal to the court, heard the appeal, and rejected it. His conviction for Lynn's murder stands. The judges' published reasons made it crystal clear. First, Justice Anthony Payne.
I have no doubt about the applicant's guilt.
Justice Julie Ward. The circumstantial case against the applicant was compelling, and there is no reasonable doubt as to the applicant's guilt. No substantial miscarriage of justice has occurred. Justice Christine Adamson.
None of the arguments advanced on behalf of the applicant causes me to doubt the applicant's guilt of murder.
We are extremely happy, and the law has done the right thing in our minds.
And what do you hope Chris Dawson does now?
I hope he sits back in his cell and enjoys the next 20 years.
Yes. And we both feel that this won't be the end. He will keep pushing.
Oh, he'll go as far as he can.
We're very grateful that justice has been done, as far as we're concerned, twice over now. And hopefully, if he's going to proceed any further, we just hope that whoever has to make the decision as to whether he's allowed to proceed any further really thinks carefully about using the public purse. Enough's enough. I think there's money needed for other very worthwhile causes as well.
This should be the last time we see Christopher Michael Dawson in a courtroom, but it won't be. This humiliation, his appeal flatly rejected by the Court of Criminal Appeal, means Dawson should finally accept the decision of Justice Ian Harrison of August 2022. It's still possible he could appeal to the High Court of Australia. The High Court doesn't hear every case. First, Dawson would have to persuade the Public Defender's Office to take his appeal. To be heard by the High Court, he would first have to seek special leave to appeal, and would have to demonstrate that it was a matter worthy of the High Court's consideration. The court says bluntly on its website, only cases of major importance are heard by the High Court. Usually that means the case raises some new point of law that hasn't been considered before, or is of high public importance, or that a High Court hearing is essential to clarify a question of law that has been decided in inconsistent ways by lower courts. The court might hear something that involves a question of the administration of justice, that is, a case that is highly significant, not just for one person, but for a whole legal system. Dawson has tried this before and failed. During the years in which he was fighting the Crown's right to take him to trial at all, he sought to have the whole case thrown out. The Supreme Court rejected him, so he went to the Court of Criminal Appeal, which also rejected him. He then sought special leave to appeal to the High Court and was knocked back. Dawson also has another criminal conviction for the unlawful carnal knowledge of a 16-year-old schoolgirl who was in his class, when he was desperate to get rid of Lynn and be with the girl. Indeed, after Lynn's disappearance, Dawson married the former pupil. In 2023, the New South Wales District Court found Dawson guilty of the carnal knowledge offence and sentenced him to 3 years imprisonment. He could, of course, also appeal that conviction and sentence. What are you guys going to do now?
I think probably field a few phone calls. We've already had dozens of texts. Just so lovely to have the support. The people in Australia and possibly the world have just been so behind this and behind this conviction holding. And we value very much the support and comfort we've received from so many people far and wide. Lots of people very invested in this story, Claire.
So, here's how Chris Dawson tried to get out of the murder conviction, where Justice Harrison found he killed Lynn Sims on or about the 8th of January 1982. Dawson had 5 grounds. First, that Dawson suffered a significant forensic disadvantage in defending himself when the matter was finally brought to trial 40 years after Lynn vanished from Sydney's northern beaches. That means evidence like statements, records and receipts have disappeared or been destroyed, and it makes it a lot harder for Dawson to back up his version of events. Here's what Dawson's barrister, Belinda Rigg SC, said about that in court. She's referring to the account of the late Sue Butlin, who said she saw someone who looked like Lynn Sims getting into a car at a fruit market on the New South Wales Central Coast. Belinda Riggs' words are being read aloud by a voice actor.
That's a very clear example of a deceased person whose evidence was crucial. That very type of detail has been lost because of the delay. All we have is an impoverished hearsay account from her former husband.
Riggs said Justice Harrison got it wrong when he failed to find a significant forensic disadvantage existed, and that he should have taken it into account when considering the evidence presented at Dawson's 10-week trial. But the 3-judge bench said Justice Harrison did adequately consider the fact many witnesses were now deceased and unable to give evidence in court.
I consider that for the reasons given by the trial judge, His Honour was correct to consider that the unavailability of Philip Day, Elva McBay, Ross Hutchin and Sue Butlin did not cause significant forensic disadvantage to the applicant.
They also said the unavailability of paperwork like bank statements, phone records and employee rosters didn't put Chris Dawson so far behind the 8 ball that he couldn't have mounted a solid defence at trial.
No error of process or result has been established.
The second and third ground of Chris Dawson's appeal are two sides of the same coin. They say Justice Ian Harrison was wrong to find that Chris Dawson's lies were evidence of his consciousness of guilt. Basically, that means Harrison found Dawson knew he was guilty and so told a bunch of lies about Lynn's purported whereabouts in order to cover his tracks. The public defender for Dawson, Belinda Riggs SC, argued Harrison gave inadequate reasons for relying on those lies as evidence of Dawson's guilt. Rigg also argued Crown Prosecutor Craig Everson didn't rely upon those lies as part of his case, and so Harrison shouldn't have either. Justices Ward, Adamson and Payne agreed. They said the language in Justice Harrison's judgment was ambiguous.
The trial judge's reasons revealed error and did not comply with Section 133(2) of the Criminal Procedure Act or the common law obligation to give reasons. Okay, deep breath here. This is complicated stuff. The accepted rule is that a lie can only be used as an implied admission of guilt if the prosecutor relies on the lie for that purpose. So, a judge or jury, in this case a judge, can only find a liar's consciousness of guilt if the prosecutor has also put it that way. And the prosecutor has to prove a few key things. The lie has to be deliberate, it has to be a lie told because the accused knew the truth would implicate them in the offence, and it's made clear to the judge or jury that there may be other reasons for the lie. And this is where Justice Harrison made a mistake, according to the Court of Appeal. They said Justice Harrison took the lies that the Crown Prosecutor said were consciousness of guilt, but also referenced other lies by Dawson, and didn't make clear which ones he thought were consciousness of guilt. This was an error in His Honour's reasoning.
The fourth ground of Dawson's appeal was that the evidence proving Lynn was dead after January 9, 1982 was inadequate, and the Crown Prosecutor didn't prove Dawson's guilt beyond a reasonable doubt. But the Court of Criminal Appeal judges backed Justice Harrison.
Having reviewed all of the evidence, I am not persuaded that the verdict of guilty of murder was unreasonable. None of the arguments advanced on behalf of the applicant by Ms. Rigg causes me to doubt the applicant's guilt of murder.
Coming up, what the Court of Appeal found about what happened at Northbridge Baths. Stay with us. The final ground of Chris Dawson's appeal was that a miscarriage of justice occurred when Justice Ian Harrison found Chris Dawson guilty of the murder of Lynn Sims. This was all about the fine detail of what happened at Northbridge Baths, the public ocean pool where Dawson worked as a lifeguard on the day after Lynn's disappearance. Dawson has always claimed he took a phone call from Lynn when he was working at the baths on January 9, 1982. Dawson had taken his 2 young daughters there on that hot January day and recruited Lynn's mum, Helena, and a friend, Philip Day, to help look after them. He said he'd dropped Lynn at a bus stop in Mona Vale earlier that day and she'd join them at some point in the afternoon. Then, Dawson says, he received a call from Lynn at the kiosk at the baths saying she was going away for a while. But after 40 long years, the people who were at the baths on that day couldn't remember if the call happened Or if it did, if it was Lynn on the other end. Justice Harrison found this story of Dawson's was a lie, that there was no phone call, and Dawson knew it. This is the point the public defender argued with. Rigg said Harrison was wrong in his interpretation of this alleged lie. Rigg also said the Crown had not actually proved Lynn was dead on this day. On Thursday, Justices Ward, Adamson and Payne found no miscarriage of justice occurred.
I am satisfied that in rejecting the Northbridge Baths phone call and other evidence relied upon by the applicant as indicating that the deceased might be alive after the evening of 8 January 1982 or the morning of 9 January 1982, the trial judge had regard to the whole of the evidence as sufficiently indicated by His Honour's reasons.
Lynn's story has really touched people.
It really has, and I think we've all said this case has just been such a landmark case, and it continues to be. There's just, it'll go down in history as, I don't know, putting benchmarks and making benchmarks, I think, for future law, and pretty astounding.
I think the best thing that we've done, we've had the arrest, we've had all the court appeals and all that sort of thing, and then we've had the trial, we've had a guilty verdict, we've got Lynn's Law into operation, and we're going to sit back and say we've done the best we can and go from there, and now we can try and live our lives again.
Let's hope and pray we can.
Yeah.
Yeah, let's hope we're free to move on now.
These three eminent judges agree with you that Chris did kill Lynn.
Yeah. I'm just having goosebumps and shivers now.
Yeah.
Mm.
Yeah, it'll hit home soon, but it takes a little while to sink in.
I think sitting here tonight and watching the news, and when it comes on, we'll just go, oh, bugger. Okay.
There it is again.
Yeah. There's always something that comes back in relation to it, but we know we've got this one, and now let's hope he just has enough sense to say, I've tried to get out of it. They won't listen to me. I'll just do my time.
Who had the best Aussie song of all time? Was it Daddy Cool, Yothu Yindi or Akadaka? Andrew McMillan and Alan Howe have whittled the long list of brilliant Australian-made tunes down to just 60 in honour of the paper's 60th anniversary. You can read the full list of the best Australian songs of all time right now at theaustralian.com.au. Thanks for joining us on The Front this week. Our team is Kristen Amiot, Leah Tamaglu, Joshua Burton, Jas the League, Tiffany Dimmack, Matthew Condon and me, Claire Harvey.